The general election matchup that seems likely between President Biden and former President Trump is about fundamentally disparate visions of the nation. Since Trump's election in 2016, the share of Democrats who see Republicans as immoral has grown from 35% to 63%, while 72% of Republicans say the same about Democrats. And a combative, Nikki Haley brought her presidential campaign back to South Carolina Wednesday after a disappointing defeat the night before in New Hampshire. She told a crowd in North Charleston that she would fight Donald Trump for the Republican nomination, and she had no plans of exiting the race. Israel has declassified more than 30 secret orders made by government and military leaders, which it says rebuts the charge that it committed genocide in Gaza. And instead, Israel says these documents show efforts to diminish deaths among Palestinian civilians. And former President Trump threatened Wednesday to blacklist anyone who donates to Nikki Haley's presidential campaign. He wrote on social media that any contribution to Haley's campaign from this moment forth will be permanently barred from the MAGA camp. And a judge ordered Wednesday that a trial be held next month to determine whether a Black high school student in Texas can continue being punished by his district for refusing to change a hairstyle he and his family say is protected by the Crown Act. This is Areva Martin in real time, and I'm your host, Areva Martin. This is your one-stop destination for today's trending news, expert analysis, and my unfiltered opinions. This is hour 2 of Areva Martin in real time, and this is the hour where we go deep, where we dig behind the headlines, and we bring you those stories that people are talking about. Well, today was a big day in the federal bribery conviction and case of former LA City Council member Mark Ridley Thomas. Today was the day that his team of appellate attorneys filed their opening brief in his appeal of his conviction. In this hour, we're going to be talking with one of his lead appellate attorneys, as well as our expert legal panel that has been with us throughout this trial. This is the only radio and streaming show that has covered the trial gavel to gavel. I am excited to be joined by Alyssa Bell. She is one of those appellate attorneys working on behalf of Mark Ridley Thomas, and she was intimately involved in the drafting and filing of his appellate brief today. Good afternoon and welcome, Alyssa. Thanks so much for joining me. Talk to us about this brief. Lots of folks who've been following this trial very carefully, very closely, have been waiting for this day. Many folks believe the convictions against Mark Ridley Thomas was based on faulty evidence, a distortion of legal principles, and are hopeful that an appeal will see the convictions overturned and his name cleared. What can you tell us about the appellate brief that your team filed today?
Thank you so much for having me. It's a great opportunity to be able to finally speak on behalf of Dr. Ridley Thomas. So we have had to keep our arguments close to the vest for some time now. As you will see in the opening brief, we've argued that Dr. Ridley Thomas's convictions should all be vacated outright without the possibility of a retrial. The government presented the jury with a fatally deficient theory of what's bribery. What's left standing at the end of the jury's verdict is a quid pro quo exchange where the quid in that exchange, the thing of value, the benefit that Dr. Ridley Thomas is alleged to have taken, is Marilyn Flynn's assistance in funding PRPI, which was an organization that his son, Sebastian, directed. That's unlike anything in the history of bribery prosecutions. In general, traditional bribery involves private enrichment, someone lining their own pockets at the public's expense. That fundamentally didn't occur here, and the statutes of conviction are a poor match for what actually took place.
So I think one question, particularly naysayers and maybe just discerning folks, I'll say, are going to be asking is, how did a federal district judge, miss those legal issues? Seemingly, as you just said, the quid pro quo, in this case, the quid doesn't line up with traditional bribery statutes. Obviously, you know that. Obviously, the team of lawyers working on behalf of Mark Ridley Thomas the team knows that. So presumably prosecutors know it as well as this federal district judge. So how do we explain the judge getting the law so wrong in this case?
This is a heavily litigated area of the law. The Supreme Court has curtailed the use of these statutes, particularly in cases where federal prosecutors are essentially trying to enforce their view of morality on state and local government actors. And to be perfectly frank, it's like a game of whack-a-mole. The government tries to expand the breadth of these statutes considerably, and the courts eventually, after much litigation, will pull it back. In a case, some years back now, the Supreme Court called McDonnell, that arose from the prosecution of Virginia Governor Jim McDonnell. The Supreme Court heavily limited the prosecution's ability to target state and local kinds of corruption on the official action side. When we think this is the other side of the coin, this is really a radical expansion of federal prosecutorial discretion, and we think the courts are going to be receptive to the need to limit that principle in the same way the Supreme Court did in McDonnell.
So listen, we know you filed a pretty substantial brief. How many pages is it actually?
I think, probably around 85 if you're just counting the legal argument.
Okay, 85 pages. So there's going to be a lot for the prosecution to respond to. What do you expect in that prosecution's brief? My understanding of the briefing schedule is that they have about 30 days to write a written response, file it with the courts, and they're going to be going through page by page of those 85 pages that you filed. So what are you expecting to see?
Well, just to clarify one point, though, we've given them a little extra time here since we've written so much. We are going to give them an extra 30 days on top. So in 2 months, we'll have their response. I expect to see, first and foremost, a recasting of the facts at trial in their own image. I think we have written what really happened here in a compelling way. We hope you'll be the judge of that, and all the public should be. But I expect them to come back hitting hard with their own narrative of what took place. And beyond that, I expect them to take a fundamentally different view of what bribery means and whether Dr. Ridley Thomas is guilty as a result.
So help us understand what the appellate court is likely to do. They're going to have these two very, I would imagine, well-written briefs on both sides. I'm giving the prosecution the benefit of the doubt because some of the work we saw, quite frankly, was not as impressive as you would have, or as me being a civil rights lawyer would have expected from a federal prosecutorial office. But let's assume some different lawyers are involved. They have a really sharp appellate team in that office, and so a judge is confronted with these two conflicting persuasively written documents. What does the appellate court do with that?
Well, our job is to convince 2 of 3. We're going to have a randomly selected group of 3 judges from the entire Ninth Circuit. And we need our arguments to carry the day with 2 of 3 of them. I think our reply brief, which we get to file about 7 weeks after the government's opposition, is really going to drill down on where the rubber meets the road here and what are the most compelling arguments that we make at the end of the day. It's a much shorter brief. It punches back at whatever the prosecution comes at us with. And then we have our oral argument where it's going to be at most, I think, 15 minutes, so not very long, to make our best points. But at that point, we will have distilled it into a few key messages that the court must take away.
So 2 things typically happen on appeals. There's a request for the case to be sent back to the trial court for a new trial. And there's a request for the conviction to be completely overturned, which means the person, as if the convictions didn't occur and there's not an opportunity for the prosecution to refile. The person is pretty much absolved from the earlier conviction. In this case, which of those 2 are you requesting from the appellate court?
We're requesting both, but our lead arguments all would result in Dr. Ridley Thomas being acquitted outright without the possibility of a retrial. We're asking for a reversal of his convictions. And if we are able to persuade those 2 of 3 judges that, in fact, the prosecution's theories are a fundamental mismatch to the statutes that they've charged, then we will be successful in that. We've also made some arguments that the district court made errors in the jury instructions. And jury instructions are an incredibly important part of the case. It's what guides the jury about how to apply the law to the facts. So if we're right and we convince on those errors that the district court made, then Ridley Thomas would get a new trial.
And just again, just kind of speculating about what might happen, assuming that the case does get sent back to the trial court for a new trial, how likely is it that on the basis of this evidence that you would see the prosecution moving forward with a new trial?
That's very hard to say. I think this case has obviously garnered a tremendous amount of public support. I would like to think that they would take the opportunity to do the right thing, but it's difficult to say that that would be the path they choose.
Well, thank you so much, Alyssa. Congratulations. I'm assuming you're probably exhausted. An 85-page brief probably means thousands and thousands of hours of legal work. It's like you've written a novel for all practical purposes, but in a much shorter period of time. But we do thank you for coming on today and sharing with us, what's happening in the trial. Like you said, this is a case that has garnered a great deal of interest, not just for folks from folks in LA, but folks across the state of California, really across the nation, because cases like this speak to larger issues in our judicial system, larger issues as it relates to who gets appointed at the top of the Department of Justice, because they are appointing those assistant U.S. attorneys in district offices, and obviously who appoints judges depends a lot on who's in the White House. So lots of issues in this case that relate to this year's presidential and other federal elections. But again, good luck to you. We'll be following this very carefully. We understand that there are going to be some amicus briefs. We're going to talk about that with our panel that will be filed as well. So we'll be tracking those and look forward to having you back once we get that opposition brief from the prosecution.
Thank you so much.
Again, thank you. Stay with us, KBLA Talk 1580. When we come forward, my expert legal panel is here to help us understand what is likely to happen with an appeal of this level. KBLA Talk 1580.
You're listening to Areva Martin in real time on KBLA Talk 1580.
We all agree that America has a very serious problem.
Okay, KBLA delegation, we need your help as we launch our 2024 Climate Justice Campaign. We would deeply appreciate you going to our KBLA 1580 website and filling out a short climate justice survey, which will help us better serve our beloved community as we build out this campaign. It'll take you just a few short minutes to complete the online survey, and the information you provide us will be invaluable as we do our part to hold folk accountable and amplify the voices of our people in this climate conversation. When you take the survey, you'll be automatically entered to win seats at our annual Black History Month luncheon, Thursday, February 29th. So hit our website at KBLA 1580. Help us out by taking the short climate justice campaign survey, and you could be our guest at our annual Black History Month luncheon, Thursday, February 29th. Thank you in advance for your consideration and cooperation. At KBLA Talk 1580, we care about the community. We care about the climate. We care about the climate. We care about the climate.
So, does anyone else's family and home need a little winter pick-me-up? If so, you've got to go to Kohl's right now. I just saved big during their winter event. I got storage bins for just $15.99 that are so needed around the house. Then I got my kids new winter coats for 50% off, and my husband some stylish boots for $29.99. Plus, because I earned Kohl's Cash on it all, I can't wait to treat myself next time. Thank you, Kohl's. Select styles, some exclusions apply. Offers valid through January 28th. See store or Kohl's.com for details.
On your period, sudden gushes happen without warning. But now you can say goodbye to stand-up gush fears thanks to Always Ultra Thins with rapid dry technology. It absorbs gushes 2 times faster than the leading store brand and gives you up to 100% leak-free protection. Hello, clean and comfortable with Always Fear No Gush.
KBLA Talk 1580.
KBLA Talk 1580 believes in community empowerment. LA's 99 neighborhood councils form the grassroots level of the Los Angeles city government. The system was created to connect LA's diverse communities to City Hall. While neighborhood council board members are volunteers, they are also public officials elected to office by the members of their community. Neighborhood councils advocate on issues like homelessness, housing, land use, emergency preparedness, public safety, parks, transportation, and sustainability. They also provide local expertise on the delivery of city services to their various communities. Neighborhood councils are open to participation by anyone who is a part of the fabric of daily life in said community. This includes those who live, work, or own property or a business. If you are interested in stepping up to join your local neighborhood council, visit www.empowerla.org. That's empowerla.org. It's time to think globally, but act locally. This is a community call to action from KBLA Talk 1580.
Okay, we are back with Mansfield Collins, a criminal defense attorney, and Bobby Grace, a veteran prosecutor. And Bobby and Mansfield have been with me every step of the way as we have been covering, KBLA has been covering the trial of Mark Ridley Thomas, USA versus Mark Ridley Thomas. And now we are at the appeal level. Deon Raymond, our justice correspondent, who has also been such an integral part of this coverage, wasn't able to join us today. But Bobby, you heard Alyssa Bell, very esteemed appellate attorney, say that she's very hopeful that there's going to be an acquittal, a reversal of the conviction that could cause essentially, be tantamount to an acquittal in this case. Tell us about your experience with appeals of bribery cases, cases of this nature, and what the percentage chance of that happening.
Well, first of all, good evening, Areva. Good to see you again. Mansfield, always good to see you. So let's start off with the proposition that in appellate court, it's very, very difficult to overturn a federal conviction. And the reason why is because, as you pointed out, generally, federal prosecutors don't go to trial unless they have a very strong case and they feel that any conviction that they obtain would be bulletproof, that there wouldn't be a chance for any appeal. I think that Ms. Bell laid out the case very cogently as to why she believes there's an excellent chance of acquittal here. And basically her argument is something that you, I, and Mansfield had talked about after Dr. Ridley Thomas's conviction, that this is a novel approach, or if you would call a stretch, in terms of using the honest services statute to convict Dr. Ridley Thomas of bribery. And Ms. Bell pointed out that this is not the traditional quid pro quo. I give you this, you give me that, and I line my pockets type of bribery case. That just wasn't what happened here. And I think in their own papers, the government acknowledges that and said that this is the only way that you can get to an individual like Dr. Ridley Thomas, who's so integrated into government that you can't actually see the traditional bribery aspects of something. But one thing that Ms. Bell pointed out in her papers, and I'm sure we'll talk about it a little bit more, the statute, she's arguing that the statute for bribery don't fit what this honest services argument that they're trying to make, and that the Supreme Court has cut back considerably on what the government can charge with respect to bribery, even in cases where an individual was lining their pockets. And that's simply not the case here. So I would argue that this is different than the usual federal prosecution. And Dr. Ridley Thomas has a good shot here of the arguments that Attorney Bell was trying to present.
Yeah, it's interesting, Mansfield, Deon Raymond, who was in that courthouse every day, like I said, wasn't able to join us, but you likewise spent a lot of time inside of that courtroom. So In some ways, you're like a proxy for Dion today. And of course, you have years of experience defending these kinds of cases and being in federal court rooms. And as Bobby said, there is this notion in the legal community that if a prosecution is brought by the feds, it's got to be airtight because they only prosecute those cases that they know they can win and that they can have held up on appeal. But as Bobby also said, from the beginning, our legal analysis, the four of us collectively, have always believed that, with every rule, there's an exception. And to the extent there is an exception to that rule, that the feds always have an ironclad case, that this was that exception. What have you seen in the appellate brief that reinforces for you that this case against Mark Ridley Thomas was in fact the exception to the feds always have an ironclad case?
It's good to be back with you, Areva, and it's always great to be with Bobby as well. Well, in the beginning, as Bobby indicated, this case just didn't seem, well, let's put it this way. In the beginning, there's a perception that if the government comes after you with an indictment, that they have the goods, that they have you. And so the legal community in Los Angeles was concerned that, oh my goodness, they must really have something on Dr. Thomas. But as it turned out, when we actually saw the evidence unfold, we were actually more shocked at that point than we were with the initial indictment, because we didn't see any evidence that was sufficient to connect any conduct of Dr. Thomas to the statutes that he was charged under. And the brief sets forth many grounds for appeal. I mean, and by the way, Areva, we just received this appellate brief just moments ago, but we're doing our best to go through it.
So you can't read 85 pages in a couple of minutes, Mr. Mansfield Collins? Is that what you're telling me?
But I can tell you this, they have filed a tremendous opening brief. And the opening brief, like Bobby said, in the very beginning, we had this view about this case, these facts. Why is this a criminal conduct case on these facts? Why does it involve or trigger honest services? We never saw that connection. We never saw a quid pro quo. We never saw the object of the conspiracy. The alleged co-conspirator never testified. And all of those claims are part of the appeal. And I think the thing that stood out when I read the appeal was something that sort of gives me comfort in the fact that I couldn't understand what the government was actually trying to do here with this novel case. The appeal says the fraud statute does not extend to a public official's receipt of perceived reputational benefits. So what the appeal is saying is we have to see an actual quid pro quo of something that involves property under the traditional notions of what a thing of value means, property. This idea that Mark.
Hey, let me just stop you for a minute, Mansfield, because you're in the courtroom, and that's one of the arguments that the prosecution made in some of the post-trial motions, is that there was, quote unquote, this reputational benefit. Mark Ridley Thomas did not want information about his son to get out to the public, and that was the benefit in the quote unquote quid pro quo. And this opening brief shoots that down and says that's not enough. A reputational benefit is not a benefit under this federal statute.
And by the way, if that was to become the law, as this brief says, this would make all conduct of public officials questionable, and it could trigger investigations, because the perception, what public official isn't concerned about his or her reputation?
But more so than that, Mansfield, they didn't prove that in court.
No, absolutely.
There was no mention of that. So how do you can't argue something in a post-conviction brief for appellate stuff that wasn't brought up at trial? This is amazing.
Yeah. And so, yeah, I think they, like Bobby said, normally it's very difficult to win a case on appeal, but there is the exception, as you pointed out, Areva. In this case, from the very beginning, when the first amount of evidence was being introduced by the prosecution. We saw exception, exception, exception. We saw the non-existence of facts related to the charges, and the appeal highlights that.
Yeah, hold that thought for me, Mansfield. When we come forward, I want to talk about jury instructions, the role of race in this appeal, because it's highlighted in this appellate brief, and educate our audience on amicus briefs. We're going to see a lot of those filed over the next couple of weeks. Stay with us, KBLA Talk 1580.
More of Areva Martin when we come forward.
I'm Amber Payton. Here's the latest on the Black Information Network. An investigation is underway after racist flyers were found papered across parts of Loudoun County, Virginia. The sheriff's office say they were left in several neighborhoods on Martin Luther King Jr. Day, and 88 more have been found since. The flyers use slurs to describe Dr. King, racist language, and references to the white knights. Officials with the Loudoun County chapter of the NAACP say incidents like this are increasing across the area. A series of ranger-led talks and guided walks and presentations are being offered by Mammoth Cave National Park in Kentucky to commemorate Black History Month. The programs are all free and will focus on the contributions of African Americans to the exploration, tourism, and development of Mammoth Cave. Black History Month will be celebrated in February. That's the latest. I'm Amber Payton on your home for 24/7 News, the Black Information Network, and BINnews.com.
Police activity in Malibu continues to have PCH north and south closed at Big Rock Drive. Right now, they are blocking 2 southbound lanes and 1 northbound lane. Northbound is backed up from Sunset. Southbound is backed up from Malibu Pier. This is due to a police pursuit that ended in a crash. And right now, stop traffic is throughout the area with no estimated time of reopening. In downtown LA on the 110 North before the 5th 6th Street interchange, Wilshire Boulevard split. An accident is in unknown lanes, but stop traffic continues from the 105 for about 15-20 minutes. And a singular crash continues to only have 2 left lanes open back in Montebello. On the 60 west of the Garfield-Wilcox interchange, stop traffic continues from Rosemead Boulevard over 35 minutes.
Did you know Discover wants everyone to feel special? That's why with your Discover card, you have access to 24/7 customer service, as well as $0 fraud liability, which means you're never held responsible for unauthorized purchases. Learn more at discover.com/credit card. Limitations apply.
This is the KBLA Sports Minute with Ray Richardson.
Jim Harbaugh coming to the Chargers leaves 4 vacancies for head coaching jobs in the NFL: Atlanta, Seattle, Carolina, and Magic Johnson's Washington Commanders. Of the 8 openings this offseason, 2 have gone to African Americans: Gerard Mayo at New England and Antonio Pierce with Las Vegas. There are now 5 Black head coaches among the NFL's 32 teams, but that's only 15%. It will be interesting to see if the 4 owners looking for a head coach show a commitment to the NFL's push for diversity. The Lakers are back in action tonight. They take on Chicago at Crypto.com. The Lakers are trying to get back to 500. LeBron is expected to be a game-time decision. He's battling a sore left ankle. He missed Tuesday's game against the Clippers. Tip-off time tonight is 7:30. The Clippers are off tonight. No debates, no speculation, just the info you need. That's your KBLA Sports Minute. I'm Ray Richardson. More news, opinions, and conversation when we come forward on KBLA Talk 1580.
At KBLA Talk 1580, we believe that caring for the community means caring about the climate. You might have heard that we announced a pretty bold 12-month, $2 million campaign to do 4 things: increase climate literacy, turn up the volume on communities of color in the climate conversation, connect everyday people with the resources they need to survive and thrive, and highlight frontline climate justice crusaders of color throughout this year. KBLA Talk 1580 will be bringing you insightful interviews on all of our shows to help raise your climate IQ. Each quarter this year, we will also be hosting free climate events in various communities throughout the city with food, fun, and forward-thinking conversations. Thanks to partners like LADWP, Metro, Caltrans, the Sierra Club, the California Community Foundation, the California Endowment, AQMD, MWD, and more. You'll also be hearing more about a couple of national town halls broadcasting live from Los Angeles, to which you will be invited. And we'll be rolling out a robust social media campaign on all our platforms, as well as an outdoor media campaign, all designed to educate, enlighten, and empower you in our fight for climate justice. Caring about the community means caring about the climate. At KBLA Talk 1580, we believe that we really can change the world. if we care enough, Climate justice, climate resilience. By any other name, we demand environmental justice in 2024. We're KBLA Talk 1580, and we don't black down.
COVID-19 renter protections are ending for City of Los Angeles tenants. Know your rights and these 3 facts. February 1st is the deadline to pay rental arrears for rent owed from October 1st, 2021 to January 31st, 2023. Residential tenants cannot be evicted without a reason or just cause. You have 5 days to respond to an eviction notice from the court. Learn more at housing.lacity.org. That's housing.lacity.org. Be informed, be protected, be at home.
My mom has taken up going to the park to practice yoga. My dad's going to a club, but not a book club, a salsa club.
Finding new hobbies comes with age.
My mom has started getting lost and not knowing where she's going.
Becoming lost or disoriented doesn't. Confusion with time or place may be a sign of Alzheimer's. An early diagnosis can help improve the quality of life for your loved one. Learn the warning signs of Alzheimer's at 10signs.org. Brought to you by the Alzheimer's Association and the Ad Council.
This is KBLA Talk 1580. Talk radio. Let's music to your ears. We're unapologetically progressive. KBLA Talk 1580.
We are back, and in this segment of Areva Martin in Real Time, Hour 2, we are talking about the federal bribery trial and conviction of former LA City Council member, former LA County Supervisor Mark Ridley Thomas, with 2 of the best legal experts around. They have been with me from the beginning, as KBLA has been the only radio and streaming network to provide gavel-to-gavel coverage of this trial, which has so many implications beyond what happens to Mark Ridley Thomas. Obviously, we care a great deal about him. He has been an outstanding public servant in LA and across the state of California, but we are in an election year, and who is sitting as a judge in a federal trial, who those U.S. attorneys are that are prosecuting cases, all of that gets decided because of elections. So talk to us, Mansfield Collins is here, Bobby Grace. Talk to us about why in this election year, having conversations about this Mark Ridley Thomas trial is so important, because somebody may be sitting at home saying, I live in New York, or I live in St. Louis, or some other city outside of Los Angeles, and this doesn't impact me. Help folks understand why this impacts all of us.
Trials do send a message to the community at large. And in this case, the community may be Black elected officials, or it just may be Black male defendants. And cases like this during election years are important because listen to what the politicians may be saying. Are they saying things that support equal treatment under the law, due process, fair hearings, or are they saying things that basically undermine all of those constitutional rights and protections? So this case is extremely important, and it's almost as if Dr. Thomas didn't want this role to be a crusader for the Black male defendants or Black elected officials. But it just simply turns out that this case is going to end up being a landmark case. And I think that for someone to carry the responsibility of being in this position, I think there probably was no better or stronger Black elected official than Dr. Thomas, which he has always shown this community and even nationwide, his commitment to civil rights for everyone. And for that reason, he was probably the right person at the right time to have to bear this responsibility. Because most people, as Bobby Grace will tell you, even when they're innocent, would have entered into a plea agreement, and he didn't.
Yes, that's such an important point. Bobby, you are a veteran prosecutor, and you know, particularly when it comes to Black and brown defendants, even when they are innocent, as Mansfield said, they often will enter into plea agreements because they don't have the financial wherewithal to hire private attorneys. They may be frustrated with the public system of public defenders, both at the state and federal level. They may be receiving so much pressure. You guys, with all due respect, have a way of making folks feel quite intimidated. And they just may feel like, they want to get on with their lives, so they'll just take their chances. And to that point, Mansfield, I remember having debates with people about Mark Ridley Thomas's case before it went to trial. And several people would say to me, why doesn't he just take a plea and try to do 12 months? He'll be in and out very quickly. Or, he's an elected official. He's going to go to some cushy camp. He's not going to go, to some abusive or, very oppressive prison. So there were people in the Black community, Bobby, who thought Mark should have just taken a plea deal, did his what they call little time in federal penitentiary or federal prison or federal, camp, and be out and go on with his life. Is that what you typically see as a prosecutor, that is what happens to the majority of Black and brown defendants?
Well, I would like to say that, Areva, that the majority of people who, certainly in prosecutions that I've been involved in, and hopefully my office have brought forward that there was sufficient evidence for a jury to find that those individuals were guilty. And so those individuals made an independent decision to avail themselves of a plea disposition. There's several reasons why somebody might decide to take a plea, but what you and Mansfield brought up are certainly things that have plagued the criminal justice system, and something that all of us should be working toward to try to eradicate. No one should be felt that they are being forced to take a plea even though that they are actually factually innocent. That simply should not happen, no matter what is happening within the criminal justice system. We talked a little bit about this, that perhaps Dr. Ridley Thomas paid a price for going forward and rejecting any offer that may have been proffered by the government in this case. And certainly we do know on the federal side that there is this jury trial tax that the government will come after you harder if you choose to go the route of demanding a jury trial. So everything that Mansfield said about Dr. Ridley Thomas and his reputation in the community, and the fact that he chose to avail himself of his constitutional rights and go to trial, does speak well of him going forward. Not only, what happened with respect to the trial, but it may bode well for him in terms of the appeal.
Yeah, people may not remember that trial tax. We talked a lot about that, and that is what is commonly known as, what happens when you do decide to exercise your constitutional right to have a jury trial, which is a right that all defendants have. And if you are unsuccessful in all or part of that, the federal prosecutorial system will be harsher and what it typically means is harsher in recommendations for sentencing. So whereas they may be more lenient and more willing to offer or to negotiate or try to compromise with you on a lesser sentence, if you do go to trial and, quote unquote, make them being the prosecutors try this case, oftentimes you will see them requesting on the higher or highest range of the sentencing guidelines. Let's talk though, Mansfield, about the issue of race. Many in the community always believe that race was a factor in this case and should have been introduced into the trial in a more significant way than it was. How is race coming into this appeal that was filed today by Mark Ridley Thomas's team?
Well, the standard of proof for the appeal is going to read as follows, I believe. And that is that in order to prevail on the appeal, the appellant, Dr. Thomas, is going to have to show that there was no rational basis for any trier of fact, the jury, there was no rational basis for them to reach a verdict beyond a reasonable doubt on all of the counts charged. Well, rational basis? Rational basis means they have to come to court and be extremely open-minded and objective and set aside any of their own biases, racial biases, stereotypes. And unfortunately, our experience with the criminal justice system in picking jurors, especially jurors that don't come from your own community, and in federal court, the jurors in this case came from about 5 or 6 different counties. And those counties did not have a majority Black or brown population. And so you end up with jurors that are coming into court with their own biases, their own elements and remnants of race or discrimination or stereotypes or attitudes. And it is a problem for the criminal justice system. It does create a problem where a lot of Black male defendants and a lot of brown male defendants argue oftentimes that they can't receive a fair trial because, like in this case, the only 2 African-American female jurors were dismissed and stricken from jury selection by the prosecution. And that is one of the grounds for the appeal in this case. The removal of 2 Black African-American female jurors. And remember, when I say African-American female jurors, I'm talking about mothers, sisters, daughters, who bring their real life experiences about the criminal justice system, about understanding the language of a Black defendant. Well, all of that was eliminated. And there's no stronger element of reason and objectivity than from a female, an African-American female juror on a jury. And they eliminated that, and they did it unconstitutionally, and that's one of the grounds in this appeal. That ground by itself, if it's upheld on appeal, will result in a reversal of this case. Just that ground.
Wow. Powerful stuff there, Mansfield. Thank you for that. Again, race has always been an issue, and this is another example of how race was used in this way, in a negative way, against Mark Ridley Thomas. When we come forward, I want to talk about other groups that get to weigh in on what should be the outcome at the appellate level. Again, this doesn't happen at the trial level, but there's something unique in our judicial system that allows the community to have a voice in appeals. We're going to talk about that when we come forward. KBLA Talk 1580.
You're listening to Areva Martin in real time on KBLA Talk 1580.
Pizza's here.
Oh, great. I'd love some, but I'm worried about my stomach issues.
If you're worried about having diarrhea, gas, bloating, stomach pain, or loose, oily stools, it may not just be stomach issues. It could be a condition called exocrine pancreatic insufficiency, or EPI. With EPI, the pancreas doesn't release enough enzymes to break down food, but EPI is manageable. Use the symptom checker on identifyepi.com and talk to your doctor. That's identifyepi.com. Sponsored by AbbVie.
It's game day at Jim's house, and the spread is impressive.
Mike's already done some damage with the hot wings, and now he's dropping back and going deep for another slice of pizza.
I sure hope he brought the Pepto.
Mike knows the Pepto-Bismol provides fast 5-symptom relief from unexpected stomach upsets. He's no rookie.
The way he's throwing back those nachos, he's the GOAT.
Be ready for game day with Pepto-Bismol.
When you have nausea, heartburn, indigestion, upset stomach, diarrhea.
Use as directed. Keep out of reach of children.
Why choose a Sleep Number smart bed? Because no 2 people sleep the same. Only the Sleep Number smart bed lets you each choose your individual firmness and comfort, your Sleep Number setting. The Climate 360 smart bed is so smart, it actively cools or warms up to 13 degrees on either side for your ideal sleep temperature. The Queen Sleep Number C2 smart bed is now only $9.90. Plus, free home delivery when you add any base. Ends Monday. Price is higher in Alaska and Hawaii. To find a store near you, visit sleepnumber.com.
You're all set with your Medicare prescriptions, Mrs. Brown.
This is not just low-cost copays at Walgreens.
I can actually help you set up 90-day refills if you want.
This is having a partner you can trust. Get low-cost copays, 90-day refills, and delivery from your neighborhood Walgreens. This is being independent. Together. Walgreens.
Restrictions apply. For details, see walgreens.com/pharmacy.
Did you know that feeling sluggish or weighed down could be a sign that your digestive system isn't working at its best? Taking Metamucil every day can help. Metamucil fiber powders help promote your daily digestive health using a plant-based fiber called psyllium. The gelling action of this special fiber traps and removes waste, so you can feel lighter and more energetic. Metamucil, promoting digestive health for a better you. Learn more at metamucil.com. These statements have not been evaluated by the Food and Drug Administration. These products are not intended to diagnose, treat, cure, or prevent any disease.
Why choose a Sleep Number smart bed? Because no two people sleep the same. Only the Sleep Number smart bed lets you each choose your individual firmness and comfort, your Sleep Number setting. The Climate 360 smart bed is so smart, it actively cools or warms up to 13 degrees on either side for your ideal sleep temperature. The Queen Sleep Number C2 smart bed is now only $9.90. Plus, free home delivery when you add any base. Ends Monday. Price is higher in Alaska and Hawaii. To find a store near you, visit sleepnumber.com.
The present. Let's get back.
All right, I am back, and joining me in this hour, two of the best attorneys in the city of Los Angeles, and I would say probably the state of California. A criminal defense attorney, Mansfield Collins, is here, and veteran prosecutor Bobby Grace. They have been with me throughout the gavel-to-gavel coverage that we have provided right here on KBLA for the trial and now the appeal of the case, the bribery case brought by the federal government against former city council member and former LA county supervisor, Mark Ridley Thomas. So the day a lot of folks have been waiting for, the day that the defendant, in this case, Mark Ridley Thomas, got to file his appellate brief. We talked to his attorney, one of his lead appellate attorneys earlier in the show. She told us that brief is a whopping 85 plus pages. The prosecution has about 2 months in which to file its reply and, well, its opposition, and then the defense, Mark Ridley Thomas, will have another 7 weeks or so to file a reply. Oral arguments are expected to happen sometime this summer. They're going to be really short, 15 minutes each. Sometimes no questions from the judges, sometimes lots of questions, but we'll continue to file the appeal. Mansfield, something really interesting happens in our judicial system when you get to the appellate level. It doesn't happen at the district court at the trial level other than through the testimony of witnesses, but now the community gets to weigh in by way of what's called an amicus brief. Tell us what that is and what you expect to happen as it relates to groups that might weigh in, and what issues might they weigh in on with respect to Mark Ridley Thomas's appeal.
Well, the appellant brief was filed by a party in this prosecution, the defendant, Dr. Thomas, and the government will now file its reply brief, a party in this prosecution against Dr. Thomas. An amicus brief allows individuals who are not related and are not parties to this action to file their sense of what was wrong or what was right in connection with the handling of Dr. Thomas's case. Most amici curiae briefs that will be filed in this case.
That's some fancy Latin, folks. Don't let it confuse you.
And that's what I was trying to say. It just means they're not parties filing the brief. They're interested in major constitutional questions of public importance that have an application beyond just the facts of this case. And they want to make sure that the Court of Appeals gets it right. And so they have invested themselves with time and money and resources in preparing what sometimes are extremely powerful briefs from neutral parties. Basically, in this case, they will be supporting the appeal and the case being made for a reversal or a outright acquittal of Dr. Thomas on appeal. That has happened in many other cases, and it's going to happen in this case as well.
Mansfield, can a group or individual file one of these community briefs you just described in support of the prosecution's case?
You know, most of the amicus curiae briefs are filed by quote unquote legal foundations, legal or colleges, schools of law, professors. It's usually something that is filed by some organization or some individual that has an expertise or specialization in this particular area. And this is an area where most of the courts, a lot of the courts have found that this statute involving honest services is so vague and ambiguous that it can't put anybody on notice of what is criminal and what is okay. And so those are the questions that will be raised by amicus curiae briefs. They will basically try to argue that this statute, in fact, is unconstitutional on its face.
Bobby, do you expect to see an amicus brief filed by some African-American led organization like Black women lawyers or Black women scholars or other Black women in particular who are concerned about the exclusion of the two Black women in this case? Might Black women say this is a bigger issue, the exclusion of Black folks and Black women in particular from trials like this, and we want to weigh in?
I think Mansfield's correct that there's a lot of different groups who may want to weigh in, as a friend of the court and bring forward information in the way of a legal brief that kind of outlines what the problems in this case were. Certainly, what we call Batson-Wheeler error, which is what the Margaret Lee Thomas's team is alleging occurred with the excusal of the two Black women. I would think that the NAACP, other traditional groups that have supported Black people over the years would want to weigh in, because jury selection, both on the state side and in the federal government, is very important. And it's a hot topic, Areva, in terms of what the state legislature has done here in California in terms of limiting how you can strike or excuse jurors on the basis of race. But now they've extended it to other areas, which would help Black, Brown, other poor people in terms of prosecutions that they are facing in both state court and federal court.
I hope that we see some legacy civil rights organizations like the NAACP weigh in on this case, because we know in this country the vestiges of slavery, legacies. One of the horrific legacies of slavery is this all-white jurors. We could think of so many horrific cases where Black folks in the South in particular, and happened in the North, but definitely in the South, where you would have a Black defendant tried exclusively by an all-white jury, an all-white prosecutorial team, a white judge, and you would see cases where people would be convicted on the scantest of evidence, on almost no evidence. And we had to fight. I mean, a part of fighting for civil rights in the 50s and 60s was to correct that issue and to prevent the exclusion, just wholesale exclusion of Black jurors. So Mansfield reminded us at a teach-in a week or so ago how important it is to answer your jury summons and to make sure you respond and that you show up at court, because if we are not there, we can't be heard to complain. And our presence on juries make a difference, whether it's a civil case or a criminal case, a state court or federal court. Having Black folks participate in the jury process is something that our ancestors, our grandparents, great-grandparents, many of them marched, they fought, some even died for us to have this right. So please, please, please take it very, very seriously. Real quickly, Mansfield, let me ask you this about how judges view these friends of the court, amicus briefs. Obviously, they're going to be looking at the main documents filed by the parties that are vested in the case, but how significant, what kind of weight will this kind of friend of the court brief have, whether it's on Batson, whether it's on this federal statute?
It could have a very significant impact, because amicus briefs by friends of the court address the bigger picture that affects public policy. And so it's not just that they are focusing on the facts in this case, but they're basically saying, and if you allow this unlawful conviction of Dr. Thomas to stand, this is what's going to happen. ABC and all kinds of other individuals who are engaging in non-criminal conduct are going to be snared into or trapped into this new interpretation of law. And so on a bigger public policy, they're going to argue, you must stop here. You must declare that this is unconstitutional. That will be a weighty position for organizations to take, like the ACLU, legal rights foundations, And again, professors specializing in this area that teach courses in this area, yes, it could have a big impact.
Wow.
Because remember, the judges went to law school.
Yeah, absolutely.
And so they will listen to certain organizations because those organizations are made up of professors or some of their former professors.
Absolutely. Have a lot of power, a lot of influence with the courts. And we should note that one of Mark Ridley Thomas's appellate lawyers is a former judge on the Ninth Circuit Court of Appeal who was appointed by Barack Obama. He's now in private practice. This is one of the first, if not the first case he has taken as a practitioner, not sitting on that court. So Mark Ridley Thomas has a dream team. He has the dean of the Berkeley Law School representing him. He has this former judge on the Ninth Circuit Court of Appeal. He has Alyssa Bell and her partners. So we're going to track this appeal very closely. We're going to look at these amicus briefs. We're going to bring you up to the minute information on this appeal. You won't miss a moment of what's happening inside that appellate court if you stay locked in to KBLA Talk 1580. Thank you, Bobby. Thank you, Mansfield. See you
Thank
next
you,
time.
Areva.
Next
Thank
voice
you.
that you hear
Thank you,
will
Areva.
be the amazing Robin Ayers in the Raw Report right here on KBLA Talk 1580.
So good to be with you, Areva. We'll sign off, I guess, huh?
Thank you, Areva.
Thank you, guys.
All right.
Sorry,
Great job, everybody. Have a good night.
we can't
All
talk
right.
about-
Same to you.
All right. See you guys.
See you.
Bye-bye.
Eric Adams is revealing a $43 million plan to make the city the leader in gender equality. Adams, who is Black, says the funding will go toward investments to help all